Good vibrations.
And welcome to what is the fifth show now with Michael O'Bernisia, aka the Bernisian. A lot of listeners will have been following the shows that we did previously in terms of the private criminal prosecutions that he's bringing against the four horsemen of the COVID apocalypse. You can get updates on his website, thebernisian.net. The last time we spoke was only last month, in which Michael expressed his optimism that his PCP case to bring these four fully to justice for all the harm, damage and loss that their lies and their deceptions and their treachery have caused was going to bring the success that he had wanted. And it looked as if things were going to work in his favor. So then disaster appeared to strike last week when he announced that the Deputy Chief Magistrate, the judge in question, had thrown the case out on the basis that the evidence presented amounted to nothing more than hearsay. And we got the news during our little Tuesday evening pub session. There's myself and a small group of truthers, and we get together every Tuesday and just kind of chew the fat and crack a few jokes and stuff. And somebody was passing around the news that this case had been kicked out. And we were all feeling very dejected. We felt as if, you know, our hopes had been dashed and the rug had been pulled from under us, and we all went away feeling rather glum and rather down. But in a private message to me, Michael said that he was feeling far from dejected, that this was a contingency that he'd fully planned for, and that, in fact, it's one of the best things that could have happened. And you said to me, Michael, it's game on, not game off. So first of all, welcome back to the show, brother.
Thanks very much for having me. It's always a pleasure. Absolutely. And I'd just also like to say, before we get into everything, because there is a lot to get through, as you know, I'd just like to say how grateful I am to everybody out there who has offered their passionate support for the case since the beginning. Our numbers are growing every day. And the first thing that I really want to say to everybody is that, as I've maintained from the very beginning, I'm well used to dealing with fighting miscarriages of justice in the courts, as is the ex-CID fraud detective that I'm working with on it. And right at the beginning, we decided that, and this is prior to it becoming public, that we were launching the case. We went over all of the evidence. We went over the statement of case that I drafted numerous times, as did many other people. We talked with each of the expert witnesses, and we made sure that all of the evidence tied in with each other, and that all of it was where it should be in the evidence bundles. And just before we started to launch our public awareness campaign, we decided that whichever way it went in the end, it was almost a certainty. In other words, we said it was 99.9 recurring percent certain that at the first attempt, whatever we file into court, the Deputy Chief Magistrate would chuck it out at the first instance. And the reason that we said that is because, having spent, both of us, more than a decade fighting institutionalized mortgage fraud in and out of court, but particularly in the civil so-called justice system in this country, where an honorable and integrous judge is as rare as hen's teeth. In other words, they don't exist. And the only way that justice is ever obtained is through often bitter wars of attrition, when one not only has to suffer one miscarriage of justice, one often has to suffer multiple miscarriages of justice in order to get to a certain point in the case where it can all be overturned. Now, it's obvious to anybody who understands strategy. I'm talking about the strategy of any adversarial contest. It's pretty obvious to people who understand strategy that when you're dealing with something as serious as a private criminal prosecution against government officers for pandemic fraud, which is murderous, it's quite obvious that the government would set in place certain things to make it as difficult as possible for such a case to proceed. And that has absolutely proven to be the case, but we were already aware of that. So we thought, what's the worst case scenario and what's the best case scenario? So we agreed that the worst case scenario at the first instance was that it would get chucked out. And then we asked the question, well, what would that mean? And what would we have to do from there to turn things around? And because we're both well-versed in both criminal and civil procedure rules, we knew that the appeal from the decision of the Deputy Chief Magistrate would be to the High Court of the Queen's Bench Division. And we also knew that in the event that we appealed it on paper, it would go to a single High Court judge who would decide the matter without a hearing in the first instance. And he would simply decide whether or not the appeal was going to proceed, in which case we'd go to court and all the evidence would be heard by that judge or a different judge. Or he would chuck it out on paper saying, no, I don't give you permission to appeal this decision. However, we also knew that if the worst case scenario came about that he chucked out the appeal application on paper, we simply have to ask for him to allow the application to be heard at a hearing for it to proceed to a hearing. In other words, the decision of the Deputy Chief Magistrate to throw out the case without a hearing guaranteed that whichever way it goes, the case is going to be heard in the High Court. Now, in other words, we go from a situation where it's his word behind closed doors against ours. There's been no hearing of the issues, of the evidence. There's been no exchange of submissions, no delivery of any kind of advocacy in order to prove the allegations that we've laid before the court. He's simply dismissed it on paper, but by doing so, he's guaranteed that on appeal, we are going to have this case heard in the High Court. And the reason, Mark, why the last time we talked before this conversation that I told you that I was smiling from ear to ear is because myself and the ex-CID detective sat down at the beginning, talked about all of this, and when it transpired the way it did, we spoke to each other on the phone, and literally, he was the same as me, smiling from ear to ear, saying, can you believe what he's done? He's now guaranteed that this case is going to be heard by a High Court judge, and we know that there is no realistic possibility that the evidence he has dismissed as hearsay can be sustained as hearsay by anyone in the High Court, let alone the appeal judge. Because the evidence we've adduced is so far away from hearsay, it is literally the opposite of the legal dictionary definition.
What sort of timescale are we looking at now with regards to this appeal being heard in the High Court? Because a lot of people are getting very weary and very downbeat about how long this whole thing has taken already, months and months and months. Are we talking many more months and months and months, or is it a matter of weeks, or what might we be looking at here?
Okay, so first and foremost, I understand why people feel that way, but I'm sorry to say it really isn't realistic. And that's why I have been drawing many analogies with fighting mortgage fraud in the courts. I've told people, as anyone who's seen the Great British Mortgage Swindle knows, the fight against Bank of Scotland lasted almost a decade. We didn't get a verdict in the High Court. We didn't win effectively the argument for 4.5 years. But once we did, everything changed. And even then, it took several years for the last mortgage to fall at the land registry on the allegations that we've laid nearly a decade previously. Having said that, that doesn't mean that this is going to take that long. And especially because my experience and the guy I'm working with's experience in the criminal domain is that generally things are dealt with, fairly expediently. The exception to the rule being our case, the fact that it's taken 5 months for the Deputy Chief Magistrate to make such a decision is unusual to say the least. And I would be very surprised indeed if the appeal, which we're planning to put in next week, we get 21 days from the date of the decision, and we're going to put it in way before the deadline, because again, like you've already said, we had prepared for this eventuality. So the appeal, it's already drafted. It's simply about dotting the I's and crossing the T's and filling in a few blanks. So provided that we get the appeal in this week, it will almost certainly be dealt with on paper within, let's say, between 7 and 21 days. We should get some kind of response from the court. But within a month, at the outside, we should get the initial decision on paper from the High Court judge as to whether or not he's going to grant permission to appeal straight to the appeal hearing, or we're going to have to present the application for permission to appeal at a hearing. Either way, the case gets heard, and let's just say that he refuses permission on paper and we go to the hearing and he grants permission at the hearing. Most of the time, in such a set of circumstances, he would allow the appeal to be heard on the same day, or say that the application for permission to appeal has been accepted, so the appeal has succeeded. That's what generally happens. However, at the same hearing, because this is a very specific and unusual type of appeal from the decision of a deputy chief magistrate to disallow a private criminal prosecution to proceed, because of that, the deputy chief magistrate will be asked to make a case stated. And that basically means he has to justify in detail his reasons, which he hasn't elaborated upon, the reasons why he set all of the expert witness testimony aside as hearsay. And as I said, that really isn't a sustainable argument, which is why he hasn't given any sustainable reasons.
Right. So we've just got the news of Hancock's resignation and the exposure of this supposed affair, which has come out of nowhere this week. It's been all over the press. Every newspaper and TV station has reported it. Do you feel that these events could in any way be connected to your case?
Well, put it this way. The ex-CID detective I'm working with thinks that it's absolutely connected with the case. And his reasoning is that they knew that we were going to appeal. And we've seen signs along the way that the protection of Hancock was waning. And again, one of the things that our instinct told us from the beginning was that Hancock was going to be the first sacrificial lamb of the four horsemen. And the analogy that I would use is that Ferguson, right at the beginning of COVID 1984, most people, if not everybody, will remember that he also got caught with his trousers down, having an affair with somebody who just so happens to be a passionate advocate of sustainable development goals. And at that time, he was rapidly insisting every opportunity he got that everybody had to obey government diktats on social distancing, etc. And yet he broke the lockdown rules and social distancing rules and the rest of it to go and have his way with his mistress. So why is it that he got away with that scot-free when he doesn't have the protection of being a government officer, when he didn't lose his job, he wasn't lambasted anywhere near the level that Hancock has taken in the past few days? So why is it that they're going after Hancock like that when they didn't go after Ferguson for the same type of moral offence and breach of social distancing laws? And why is it that when the trip to Barnard Castle to meet with GSK and cut the GSK Sanofi deal was done by Cummins, when Cummins went to Barnard Castle, why was it that he wasn't forced into resignation? Why wasn't he sacked from his position, which was probably the most influential civil servant at the time? or even higher than that, some would argue. But nevertheless, we see that in this particular case, it's not enough for Hancock to betray his wife and his family by cheating on them. That's not enough for him to resign. Boris did that, and Ferguson did that, and that wasn't enough for them to resign. Why is this? Well, even though it wasn't enough for Ferguson, it's enough for Hancock to have breached social distancing laws, because he's still banging on that everyone has to obey them. And quite frankly, Mark, I don't buy it for a second. I absolutely think this is a ruse. It's an excuse, because the real reason is Hancock has already been caught red-handed by the High Court, giving PPE contracts to his family and friends, and it hasn't even come out whether or not, and I'm sure the answer is yes, whether or not there are accounts containing the slush money that he's been siphoning from government funds via Port and Biopharma Limited or some other such legal entity. And they're simply looking for an excuse. They don't want to say it's because he's been caught committing fraud and he's already accused of pandemic fraud in the PCP, and nobody's happy about that in government. And so maybe it's coming home to roost that when he was a junior MP, his nickname, so we've heard from the inside, Hancock's nickname as a junior was an accident waiting to happen. If that's the case, this is the denouement of what kind of character traits that assessment must have been based upon. Because not only has he told so many blatant lies to the public and to Parliament, and no doubt to his wife and family, he hasn't done it very well. He's done it very badly. He's contradicted himself so many times. And I think they just said, look, this is the excuse you're going to use, because we're not going to tell people the truth, because that will only give our adversaries greater ammunition to fire in our direction. So this is going to be the excuse you're just going to have to tell your wife. And I think that's why his wife doesn't seem too upset. There doesn't seem to be any acrimony that's brewing. No talk of divorce yet or who's going to get the kids, because my gut is saying that she's in on it.
Yeah, he's been told to fall on his sword.
Yeah.
And this woman, this aide, nobody had heard of her before last week either. She just seems to have come out of the woodwork.
That's right. And isn't it just ever so reminiscent of the way Monica Lewinsky just came out of the woodwork at the exact time the Clinton's enemies needed something on him? No, and there are many accusations that she was working for Mossad now as well.
A lot of people suspect that video that's been widely circulated is some kind of hoax as well, or some kind of setup at least.
Well, put it this way: on the edge of the shot of so there's a wide shot for anyone who hasn't seen it. There's a wide shot of this office where the assignation is supposed to have taken place. There are the decor is similar. There's no doubt about that. The floor is similar, but it looks like a completely different color. They might say, oh, well, that's just, a graphics issue in the transposing of one format to another. But that doesn't normally happen. And there's also a door handle that the papers are pointing to, or the tabloid journalists in the papers are pointing to, say, look, this is the proof. This is the same door handle. And then there's a smaller shot of a door handle, which they're saying is the same one as the one in the wide shot. And yet the door handles are pointing in opposite directions. So there are inconsistencies in that evidence. And it's just, well, who's in control of the CCTV footage where Hancock works? Who's in control of it?
Yeah.
And why is it that CCTV never works when the people need it to, when the state has committed a crime?
Matt Hancock, raging, Mr. Loverman, ladies' man, Lothario. Who knew?
Nobody.
Would have guessed. There's a document that's been in very wide circulation lately. I've been sent it about 200 times, and it purports to be a leaked Imperial College memo that is said to be authored by Ferguson, instructing for the UK to be put into pretty much permanent lockdown from, I think, the 15th of July is the date that's given. And it's a real horror story to read because they're talking about all kinds of draconian measures that are harsh even by the standards that we've undergone already these past several months. Have you seen that document, and do you suspect that to be genuine, or is it more likely a hoax?
I have seen it, and it is a hoax, yes.
Yeah, I was pretty sure it was.
Yeah. If you look at the way it's written, and then compare it to, for instance, the Imperial College model on the Imperial College website, which you can find relatively easily, which is part of the evidence in the case. And if you just look at the language that is expressed in that, and then which Ferguson wrote, and then you compare it to the words that he supposedly wrote, you would see, if you're used to looking at different styles of writing, as I am, you see the stark differences between the two. There's no way that they were written by the same person. You said, but it's not just that example that I have. I also have other papers by him that I've read, and other articles that I've read. It's not in his writing style. And more than that, there's one thing that is very noticeable, and this is very common as an attribute in terms of the writing styles of academics, or even though he's not qualified as an academic, let's say he's an academic. And one of the traits is very often that they are methodical enough not to make very obvious grammatical errors, spelling errors, missing words out. And within the first few paragraphs, there's a missing word, and the language isn't right. And it's quite clear, because this isn't the first of its type that I've seen. It's false evidence put out by the counterintelligence brigade, because they want people who are good researchers to get fooled by it and then say, hey, look, this proves everything we've been saying is true. And then it's later debunked as being bullshit. And then whoever was saying it was true looks like they don't know what they're looking at. So it's a common tactic. There's no doubt about it.
Yeah, it's kind of reassuring to hear that that is a hoax, given what it presented, but I was pretty sure it was. So something else that's been in wide circulation lately has been this video from Mark Sexton, who's a former police constable. And he went into his local police station in Warwickshire, I think it was last week, and presented evidence of the British government being involved in fraud and crimes against humanity and genocide, and asked them to investigate. And they are obliged to investigate when they get a case such as that brought to them. I imagine you're familiar with that one. Do you feel that in any way his action could complement your own? Or is that something that stands outside of what you're doing? And do you feel it has value and merit in its own right?
Well, put it this way. I've been aware of what Mark's been doing for a number of months. Certain people that I'm working with are assisting Mark. So yes, there are absolutely crossovers. And if you're asking whether or not the cases complement each other, they do, because they're essentially arguing the same kind of crimes. The approaches are different, obviously. One approach is to see, obviously Mark's approach is he's been trying from the beginning to get the police to investigate the alleged crimes. And our approach is to get a jury to decide whether or not there's already enough evidence to convict the four horsemen of very similar crimes. So yes, there are definitely crossovers, and there are, as I say, people who are involved in both cases. I also have experience trying to get the police to investigate the criminal elements of mortgage fraud. And a lot of people who I've worked with down the years have been to police stations, sometimes with dozens and dozens of other people, to attempt to get the police to investigate what are plainly fraudulent mortgages that are being routinely enforced by Her Majesty's courts. And thus far, even though on certain occasions crime numbers were issued, there has not been one single investigation that commenced because of those actions, even though they were absolutely with the best of intentions. And like Mark's, the police should be investigating, because he's providing more than enough evidence to provide reasonable suspicion for them to start investigating. But of course, The problem is, and this is the problem for all of us, we already live in an authoritarian police state where it's virtually impossible to get any crime that the public might report investigated by the police, unless, of course, they're reporting some alleged hate speech on social media or breaches of COVID regulations, not laws. And at this point, I just want to insert what may seem like a pattern interrupt to some people who understand what a pattern interrupt is, and say that as of today's date, there has not been one single successful conviction of anybody under the so-called COVID laws, because they don't exist. In other words, they're unenforceable. They're simply rules and regulations. So we can go back to what we were talking about. I just wanted to make sure anyone who was listening was under no illusions as regards whether or not these are laws we're talking about. We're talking about royal decrees, the equivalent of royal decrees, of government diktats. And as far as I'm concerned, relating it back to Mark Sexton and anybody else who is genuinely standing on the front line, not part of any controlled opposition group, I've got the utmost respect for them, because we're all on the same side. But if you're asking me how many people are actually standing on the front line who actually are who they say they are and can be trusted, that number is a lot smaller than people think.
Yeah, we've discussed that before, haven't we?
We have.
So with the DCM having chucked out the case at this stage on the grounds that there's not enough evidence or it amounts to hearsay, do you feel the four horsemen will have been celebrating since this decision? Or do you feel it's more likely they'll have been silently crapping themselves because they know now what the next stages will involve?
First and foremost, I'll answer every aspect of the question, but I want to start off just clarifying a couple of things. Firstly, the dismissal at this stage without a hearing is the beginning, as we talked about at the start of the show. It's the beginning, not the end. The reason given is that the expert witness testimony in the form of 11 sworn witness statements, the judge has claimed that it's not prima facie evidence because it's hearsay. Now, the legal definition of hearsay is that which you were told by another and you don't know yourself. So in other words, if I say to you, Mark, you know what, I heard this about such and such, that's hearsay. However, if I say to you, Mark, I know this about such and such because I saw this and he did that, that is evidence that I know myself. And if that evidence is sworn in a witness statement and presented in a PCP, for instance, it in no way, in accordance with the legal definitions, can be considered hearsay. Now, this would explain why the judge has given no reasons backing up, i.e. he's given no examples of any hearsay within any of the expert witness statements. And the reason for this is because, let's just say that there's a good chance that when the DCM has to present those reasons in the appeal hearing, I will be able to ask him certain questions. One of the questions that I will be able to ask him is, can he point to just one example in the 11 expert witness statements that he set aside as hearsay? Can he point to one single example of hearsay when one of the witnesses states that they know something or they think something because of something else that somebody else told them? And there is not one single example of that. In other words, his entire reasoning for chucking out the case or not letting it proceed can so easily be rebutted. I can't imagine how this hearing is going to take longer than 20 minutes, and they often take hours. But anyway, let's set that to one side. Because apart from that, the situation with regard to the four horsemen, they would have only been celebrating in the event that we announced that the PCP had been dismissed by the Deputy Chief Magistrate and that we were given up because, you know, he's made his mind up, we must be wrong, even though he hasn't given any reasons. They would have been celebrating then, and everyone else would have been looking for me with bloody good reason. because I've said from the beginning that we wouldn't give up no matter what. And I meant what I said. I know lots of people don't mean what they say, but I do. And the fact is, so does everybody who I'm working with on this, and everybody who is supporting the case. The fact is, the case now, since I released that news that we were appealing his decision, support for the case has grown. It hasn't decreased, and it's grown substantially. And the messages that I'm getting on a daily, well, no, hourly basis are from people saying, you know, this is proof of what you already knew already, you know, from fighting the mortgage fraud, that the system's rigged to protect these criminals from the consequences of their crimes, which is, of course, something I've been saying for a number of years, along with a lot of other people who I've worked with on the mortgage fraud and other issues. However, when Hancock resigned, a few days after we announced that we're appealing it, well, put it this way, if he'd resigned just after the DCM had chucked out our decision and we'd announced that we were going to appeal it, I would have been extremely surprised. It would never have happened that way. What I believe is happening is what was exactly as I alluded to earlier in the show. What we're seeing happening is exactly how protected Hancock is now, which isn't very protected. And they've tried to throw him under the bus in the hope that they can regroup and stop making so many calamitous mistakes, which could potentially be used by us in the PCP or anybody else who was running legal proceedings against them. But I also think that given the fact that this is happening now, a few days after it became public knowledge that there is now sufficient evidence in our possession and in the possession of other people who have been working on this behind the scenes, who I absolutely trust implicitly. And if I'm going to specify, I'm going to say Claire Wills has done an absolutely spectacular job getting to the bottom of what she said to me right at the beginning. She believed to be evidence that they were bumping off people in care homes using midazolam. Well, a few days after it was confirmed that we can now prove the same kind of bulletproof correlations again and again between the death spikes in the care homes and the administration of midazolam as we can with the COVID vaccines and the supposed COVID death spikes. Since that happened, Hancock's resigned. And that came just after we announced that we were going to appeal this. And in that blog post that announced the news, anyone who's read it, and if you haven't, go and read it, because you will see the detail of what I'm talking about today. You will see how there is no realistic possibility that there could ever be a just refusal of permission to appeal in our case, because the grounds are completely empty. There's nothing to them. He's standing on quicksand with his decision. So if you accept that as the case, what this means is, going forward, Hancock's resignation actually means Hancock is more likely to blow the whistle on what's really been going on behind the scenes, because he hasn't got the protection that is being still offered to Ferguson. Why should they give more protection to Ferguson, who's done exactly the same things as Hancock has had to resign for? Why should they do that? Well, if I was Hancock, and bearing in mind his overt narcissism and self-serving nature, if I was him, I'd be hopping mad that Ferguson was protected above him when Ferguson has told more lies than Hancock.
Well, you make good points, and it is indeed interesting timing, the way it's all converged. So I think that pretty much brings us up to speed, Michael. How would you like to leave things for the listeners? What sort of note would you like to leave things on for this show?
I would like people to understand and appreciate that I'm not trying to tell anybody that they should be happy instead of disappointed, because the best of all situations would have been the DCM saying, oh, look, you know, I'm going to let it proceed. There's easily enough evidence. I'm going to get behind the case. Of course, that should have happened. I'm not saying that people shouldn't be disappointed about that. What I'm saying is that those of us who've been fighting miscarriages of justice in this system for years, knew that in all likelihood it would happen, and therefore we were prepared for it. So given that, what I'd like people to take away from this show is to know in their hearts that what's really happened is battle has commenced. In other words, what I'm used to doing more than anything else in the legal realm is overturning miscarriages of justice. How do I do it? Do I do it by playing by their rules? Of course not. I do it by knowing the right strategies to use in the right circumstances and knowing when is the right time to do something and when is the right time to wait for our adversaries to do something. Well, now we're in a different state of affairs altogether, because now the ball is in our court, and this is the exact position, different subject matter, but it's the exact position from which I overturned 4 judges' decisions in the High Court dismissing my evidence of mortgage fraud against Bank of Scotland and its LPA receivers as totally without merit for 4.5 years non-stop in every single civil court. I was banned from every single court in the country for 2 years, and we still won in the High Court at the third bite of the cherry when they issued proceedings against my family, and we overturned the whole thing and got a judge to admit that everything that he and the other judges had dismissed was correct. Now, I don't want people to think that it's going to take that long, as I said before, because these circumstances are different. The criminal domain is different. And in the criminal domain, I do have experience of running a PCP and getting over the first decision, which was to set everything aside as rubbish. And I got over that one. And the final decision in that case for my family's PCP against Bank of Scotland was the senior district judge dismissed all the bank's applications, and he said that if just one mortgage was cancelled by the land registry on the same grounds I was alleging in that case, then James Crosby and the rest of his board and the receivers would proceed to answer to the allegations before a jury. Now, that was 2013. And compared with what I know now and the experience that I have now, I knew nothing then. This, in terms of the situation in the PCP, rounding things up, as it were, for me, this means that now I don't have to sit around waiting for my adversaries to make their move. They've made it. And quite frankly, this, in other words, the appeal that we have before us is the nearest to a slam dunk appeal I have ever seen. And the only way we can be beaten is by yet more miscarriages of justice. And if that happens, well, we know exactly what to do, and we won't back down until we win.
All right. Well, your comments there certainly put a different slant on things to how it appeared a few days ago. So thanks for setting the record straight. Of course, we all wish you the best of luck as ever, and we'll hear back from you again soon, no doubt. I'm sure we'll be doing another one of these when we've got more to say in due course. So thanks for coming on again today.
You'll be absolutely one of the first to hear when there is news, Mark. And once again, thanks so much for the support that you've given from the beginning. It really is greatly appreciated.
This is just a wrap.
I'm picking up vibrations. I'm picking up good vibrations. I'm picking up vibrations.